Good morning, good evening, good afternoon, everywhere in the world. Thank you, Scott, for the nice introduction. Let me just briefly share my screen so we can get started. Okay, that's probably this one here. Okay. Very good. So as Scott said, my name is Andrew Hartz, and I will be presenting here in representation of Global IP Europe in Munich. And as happens, we seem to be now the last session of this tour. So we're coming to the grand finale. And today I will be talking a little bit about filing applications in Europe, the different modalities we have, what we can do, and some general basic facts about filing in Europe. And the way this works is I hope that the session will be relatively interactive. That means I would be inviting you to post your chat comments at any time, and I will pick up on your questions. So please don't hesitate to interrupt me. Of course, you can post questions at the end of the session, but since we're going through each of the topics, there's no problem in you immediately responding in the chat, and I'll pick up your questions as we go along. Okay, so just a brief introduction. GIP Europe is situated in Munich and has two main partners, that is Ms. Tomoko Imazumi and myself. And I would like to today talk about general filing matters in Europe. And as a brief introduction, a reminder, okay, here we have the geographical map of Europe and the EU states. As you will note, the UK is no longer an EU state. And then on this slide, I'm showing you now the EPC states. So these are the states that are member states of the European Patent Office. And you will notice that some of these are green, which means those countries are part of the European patent system, but they are not EU states. So that's something to keep in mind. We have countries like Turkey, Norway, UK are actually part of the EPO system, even though they are not EU states. Okay, which options do we have for filing in Europe in general? We have direct filing, of course. You can go to the national offices. You can use the Paris Convention priority or the PCT, or you can also file utility models. And each of these I'm going to touch on today just briefly and hope that you also have some questions on these topics as well. Okay, so national filing, of course, works by filing at the national patent offices. In Europe, this is in particular the German Patent Office and the UK Patent Office. These two have the longest traditions and the most filings. They also do examination. And if you file via the national offices, probably these are the two you're going to pick. After that, you get a national application, which then eventually proceeds to grant, of course. So what is the advantage of filing directly? Well, you get protection in multiple countries, of course, if you file in multiple countries. The problems are that you have multiple applications, you have translation issues, and the examination process kind of repeated for each country. And it's also difficult to file everything on the same day. So that's, of course, why we have the Paris Convention, as you all know, which is basically the mother of all patent laws. It solves the issue with having to file everything on the same day because you can now file afterwards within 12 months, claiming priority. That's obviously very helpful, but it still has some issues. So we'll see later how those are solved. Paris Convention is now already in force in 195 countries. I checked that number today. So that's basically everywhere, nearly everywhere, except for very few countries who are not participating. It's one of the oldest treaties, in fact, and so it's not surprising that over the years many countries have joined, but nevertheless, it's pretty ubiquitous coverage, so quite impressive in its own right. And the main point of the Paris Convention, of course, the priority right, which you, of course, are all familiar with. And as happens, subsequent patent laws, which all came later, have incorporated a lot of the rules from the Paris Convention. You know, you get the 6 months surcharge period for annuities, and a lot of other things are genetically related to the Paris Convention. Also the same for Europe. And the main point of the Paris Convention, of course, this backdating of the filing date. And so if you have here the Office of First Filing could be maybe JPO, USPTO, or China, or Germany, whatever. If you have a filing date here starting at day 0, and then 12 months priority period, you will then be able to file subsequent applications within that 12-month period, gaining the effective filing date here. Okay, the problem is that later applications will not be new compared to the first filing. That's kind of solved by backdating with claiming priority. So it's as if you were filing all these later applications on the same day here, this day 0. Obviously very useful. And this comes from Article 4 of the Paris Convention. And here you can find all the interesting points here. Application for a patent could also be a utility model. In countries of the Union, as we saw, that's nearly every country in the world. Or its successor in title, that's also one important point that you have to keep in mind. And you get the right of priority for anything that's equivalent to a regular national filing, so also utility models. And as long as you have a filing date, and that gives you then finally the 12 months. So everything here that you know about the priority rule can be found in Article 4 of the Paris Convention. That's basically the same rule that we have in Europe, nearly identical wording, in fact. And this gives you this priority right. Okay, but as we know, priority only works in certain conditions, 12 months. That's the same in the EPC. And only for the same subject matter, and only if the applicants are the same. So this is then the first, maybe a little bit difficult thing that I'm going to present today, because of course you're all familiar with the priority right, but this last point here, same applicants, okay, this can cause a lot of problems, especially if you're coming from the US. Why? Because the US typically has all the inventors as applicants, or at least it used to do. And many times you will find US provisionals, you have the inventors, and then some filing with the inventors as applicants, which is then later follows up maybe with a PCT application, and suddenly you have the company as the applicant. Now, this seems to be no problem at all in the US, but it's a huge problem for Europe because we strictly adhere to the wording of the Paris Convention. And the Paris Convention says the same applicants. So if you start off with the inventors here as the applicants, maybe these 4 here, and then suddenly afterwards you have the company as the applicant, you have switched applicants, which means that by the rules of Paris Convention, you are no longer entitled to the priority. And this has been enforced frequently at the European Patent Office. For example, the super famous CRISPR-Cas case, I'm sure you've heard of CRISPR-Cas, where basically one of the applicants lost their priority because of this problem for a very, very valuable patent, and then could not, even in appeal, they could not gain this priority right anymore because they switched applicants and they didn't transfer the priority right before filing the PCT application. Of course, switching applicants per se is not a problem if you transfer the rights. So if you have a contract between the inventors, an assignment, transferring the rights to the company, then that's no problem at all. But if you don't do that in time before you file a PCT application, then at that stage you've switched applicants and you have no excuse for it, and there you will lose the priority right. So this caused a lot of problems in Europe, and a lot of patents have been lost in this way. That's why I'm just picking this up. But recently, just last month, we had a new decision, G222, from the Enlarged Board of Appeal. And this is a little bit different now because the case law now says there is a rebuttable presumption that the applicant is entitled to the priority right. So basically, the burden of proof has been shifted to the attacking party, who now have to show that the current applicant, which is usually the company, is not entitled to the priority right. Okay, so that obviously makes it a little bit difficult because the attacking party, the opponent, will hardly be able to provide facts and evidence that a contractual relationship has not been established. That's going to be very difficult. This means in practice that the EPO will probably be giving the benefit of the doubt to US applicants who fall foul of this trap, and they will be entitled to maintain the priority in the future. So probably this danger has been kind of diffused, and we now have a more lenient situation where you probably very much more favorable for US applicants. Okay, so no questions so far, and that was a pretty tough point to bring. I was going to show mainly, not so much case law today, mainly basics and give you a good overview of everything. But this is a little bit of an exception. I thought I'd bring that because it's recent case law and relevant for US applicants. Okay, but as I say, any questions are welcome at any time. So I'll be keeping an eye on the chat. And if you have anything, please go ahead. Good. So Paris Convention, problems with the Paris Convention. Of course, it's expensive, multiple filings. You have issues with translations, repeated examination process. And the solution to this is typically regional filing. And that is what the EPO is. It's a regional office which combines various national states who have transferred their patent competence to the EPO. And the EPO then grants patents for these European countries. We also have, of course, 2 African regional systems. We have the Eurasian system with Russia and Kazakhstan and so on. And there's also a Gulf state regional office. But today we're going to focus, of course, on the European system. What is regional filing? Well, you have a common office which caters for the whole examination process from multiple countries, simplified language regimes, one filing and getting the same effective date, one examination process, and then protection for the whole region. Simplified formalities, and basically solves a lot of problems. But it's still not worldwide coverage. Yeah, that's probably going to be difficult, but at least the European EPO system covers for a lot of the European states. And as we saw in one of the entry sites, it's basically nearly the whole of Europe you can get with filing at the EPO. Okay, so the EPO has 3 main offices, the headquarters in Munich, then a big examination office in The Hague, and a small office in Berlin. And as you all know, the lifeline of a European patent is pretty similar to most other patent systems. You have publication after 18 months, followed by examination, grant or refusal, typically within 2 or 5 years. What we then have is opposition proceedings 9 months after the grant, which can lead to revocation or maintenance of the patent. And you could, of course, abandon the patent at any time until the term ends after 20 years' time. What you don't see on the slides here is revocation proceedings, nullity proceedings, which can also happen. But for the European system, they are either held at the national offices or at the new court, the Unitary Patent Court, the UPC, caters for that as well. So even after opposition, any party can challenge a patent if they are willing to sue or prosecute such a case at revocation courts. Those are typically the national courts. Okay, Filing at the EPO, of course, the invention goes to this guy, which is the representative, European representative, then files the application at the European Patent Office, who then produces a granted patent if everything goes well. We have 3 working languages at the EPO, English, French, and German. So you can file in any of these languages. There are different possibilities as well. You can also file in Italian, but then translate. But you can't file in, I don't know, Chinese or Japanese, except for the very first filing. So it's possible to submit an application in Japanese or Chinese and then translate, but the whole prosecution has to be then done in these 3 working languages. That's actually a good idea to file in the original language if possible, because you can correct a translation at any time. And that avoids the problems you might have if you filed your translation immediately. So you had a Japanese application, you filed immediately in English at the EPO, then you could not correct this English translation if there were any mistakes. But if you file first in Japanese or Chinese or Portuguese or whatever, and then file the translation, the original language is then the Japanese Chinese language, and you're entitled to correct the translation anytime. So this is generally, if you're doing direct filing without PCT, then I would advise to file in the original language at the EPO to avoid such mistakes. Okay, filing date in Europe is fairly easy to get. You just need to indicate that you want to have a patent somehow and some kind of description and some contact address. That's all you need for a filing date. Typically, this will be a request for grant and description. Eventually, you do need claims, but for a filing date, initially you do not. So this is different compared to the PCT, where you need to file claims. So in Europe, you first only need to file a description, and then you can subsequently follow up with claims. But typically, of course, your application will include claims, and it will be a full and complete application. Filing date, of course, is very important to get because that's the trigger that starts the full procedure. If you don't get a filing date, then you have basically nothing in your hands, and the EPO will not even consider whatever you submitted. It will just be deemed not filed. So this is an important trigger point to get a filing date because that starts the prosecution at the EPO. Okay, so then formal filing requirements, these you don't really need to worry about too much. That's our job. But basically the first stage is to check the formal requirements, and these are whether there's an abstract, did you claim priority, is everything properly translated, do you have a claim, have you paid the fees, did you file everything in the proper format? And if you did not, then you will get some communications from the EPO, possibly a Rule 57, upon which you can remedy your defects. And if you do not, then of course the EPO will issue a communication that the application is refused. But these typically do not constitute big hurdles for getting a patent. The big step, of course, is the examination proceedings. And when we look at the lifeline of a patent, mostly you will be receiving a European search report as one of the first communications, which we then do have to respond to, usually, not always, but usually. And after that, this will be followed up with substantive examination, where we then communicate with the examiner before he then refuses or grants. So this is where the attorneys are then doing the work. Here in substantive examination, responding to the search report, responding to office actions, and moving this along to grant. Okay, so we have 2 phases. We have the search phase and the examination phase. And the search phase will typically be concluded with a search report, and the examination phase produces office actions, which we have to reply to. I think you're pretty well familiar with this. I think the difference in the European system compared to most others is that you've got this disjunct search and examination phase historically. Although these days the search phase includes an office action and examiner's report, the extended European search report. So basically, it's kind of like the first step in examination now. So the difference between these two is blurred, but it used to be more distinct. Okay, still no questions? Good, everything clear. So when we interact with the patent office, our intention, of course, is to get this communication rule 71.3, where the examiner says he's going to grant this and this patent. And if we accept and pay the grant fees and translations, we will then get a grant, which is then published in the European Patent Bulletin. And that publication date is the starting date of protection. That's an important date. It also triggers the opposition period, but it basically, this is the time from which you get full protection. And of course, in Europe, we have Article 123.2, which says you cannot amend to subject matter not disclosed in your original application. I mention this because the European system is very strict on added matter, as you probably know, very formalistic, and therefore this is an important rule to abide by. Good, so we have a kind of summary of the EP procedures. We have grant phase with filing the application, search and examination. If the examiner isn't planning to refuse, he will summon us to oral proceedings. That's a formal pseudo-court proceeding with 3 examiners who then decide formally either to grant, possibly in an amended form, or not to grant. If they do not grant, we can appeal, which then also is followed up by oral proceedings, and then a decision either to refuse or to grant. And if everything goes well and we get a grant, then we have 9 months in which other parties can file opposition, which will lead to opposition proceedings, and again at the end oral proceedings, which is followed up by an opposition appeal procedure, oral proceedings, and then finally decision to revoke the patent or maintain the patent. So as you can see, there's a lot of oral proceedings going on here. This is a characteristic of our patent culture in Europe, that the right to be heard is upheld and is a very strong principle, and therefore no decision can be taken against the will of the applicant. If they request oral proceedings, then oral proceedings have to be held before a final decision can be taken. And we do often have these oral proceedings. They are very interesting and sometimes dramatic, especially in opposition. You get the decision at the end of the proceedings, so it's always a little bit of suspense there before they finally decide on inventiveness or not, usually. And so this is a hallmark of our patent DNA. It's very, I would say, that spices up the system a lot. It's not too expensive, nothing like US opposition proceedings. So, you know, this is something that we commonly do, and it's much appreciated. It's a typical way to check the examination process to make sure that everything has been said that can be said against a patent. So once a patent has survived opposition appeal and it's still maintained, it has a certain amount of stability. So you can trust the patentability of a patent that has survived appeal opposition. And when you go into infringement proceedings, although the patentability will then be examined again by the national courts or the UPC, they do have the last word on patentability. But of course, a patent that has survived opposition at the EPO will have a much stronger standing and will probably not be changed too much in infringement proceedings. Okay, so, oh, great, there is a question here. Yes, very good. So, how many office actions chances does an applicant get before final refusal going to oral proceeding? Okay, good question. So it depends, of course, on the case, but typically, let's go back a slide. Typically, you will get one European search report. So this will be extended with an examiner's communication. So here you get one. This is guaranteed. Then you reply, and after that, you could theoretically go to a 71.3, which means you could go straight to grant. But usually you get one, maybe two further office actions. So I would say typical cases have 2 to 3 office actions, one search and 1 to 2 examination phase. And some tough nut cases can have more. But it used to be more common to get like 4 or 5 office actions. But these days, the process is much more streamlined. And actually, if you go 4 or 5 rounds with the examiner, which you can do in Europe, it doesn't cost extra. But if you do that, then something's gone wrong in the communication with the examiner. It means that you've been sort of missing the point each time, or you've been kind of salami tactic. You keep amending the claims a little bit. And if you do it that way, you keep amending the claims, then the examiner can't really summon to oral proceedings because he has the impression that the procedure is still going ahead. He will only summon to oral proceedings if he thinks that there's no movement. So if you leave the claims the same as they were before and just argue and he's not convinced, then he will summon to oral proceedings to refuse. But if he has the impression that you are narrowing down your claims progressively and it's kind of going the right direction, then you can string along 4 or 5 office actions. But that's usually a sign that you've probably been wasting time because maybe the first 1 or 2 you were discussing added matter and clarity issues, and you didn't really get around to novelty and inventive step. And then you end up with 3 or 4 office actions. Doesn't cost you extra, just cost time and of course the attorney fees. But yeah, that's more unusual these days. And sometimes if it's a very clear case for a grant, you can get a grant after the search report. Next stage could be 71.3. Intention to grant could come immediately, especially if you have like PPH or something where you already have a certified patentable material and you already narrowed down the claims sufficiently, then you could easily end up with a grant immediately. But yeah, to answer your question, it's about, I don't know, 2 to 3 office actions, I'd say. I mean, on the flip side of this, of course, if you immediately get a grant and you went in with amended claims, it's also like, did you really fight hard enough as an attorney? Why is the examiner granting this immediately? Are the claims so narrow? There's also that to consider. So you want to put up a little bit of a fight with the examiner about the scope. And so 2 to 3 office actions are kind of a good number. Okay, so another question here. What I'm hearing is that there's much more incentive to get to the point in the EPO practice compared to the US. Oh, my first answer to that is I wouldn't say so, because the sanctions in Europe are far less. So we don't have any RCEs or any, it's not like I'd say like like in a casino or a slot machine where you have to like throw in the machine and then pull the lever again and you get another round. It's not like that. We just pay one fee for examination and then we can keep going until the examiner says he's had enough and wants to call to oral proceedings. So from a point of view of costs, there's not necessarily a big incentive or pressure to get to a conclusion. Whereas from my experience in the US, if you don't get anywhere with the examiner, you end up with RCEs and continuation and divisionals. and that gets expensive and it's a lot of hassle. So I wouldn't be sure that I would agree with that. But of course, in general, because of cost issues, attorney costs, of course, we attorneys try to focus down and to get a patent granted efficiently at all times. So there's an incentive in both patent jurisdictions, US and EP, to get to the point and not to waste time with the examiner with formalities or make mistakes with added matter. I mean, that's when things start to really get messy, because you have 3 rounds of added matter, and you've made amendments that are not acceptable to the European examiner. They maybe would have been in the US because you have a much more lenient practice there. But, we have to try and get our US representatives and US colleagues to watch out more for added matter so as not to waste too much time on these kind of issues before we get down to the nitty-gritty of novelty and inventive stuff. Right. Okay. So one more question here. How does the unitary patent system help to cut down the cost and streamline patent application process in Europe? Okay, I will answer that question in a minute. We'll get to that shortly. So please hold on with that question. Unitary patent system I can talk about in just a couple of slides. One more question. Is there any way to delay paying the annuities applicable before grant of a patent? Before grant of a patent. Annuities. Okay, that's a totally different spin, because annuities in the European system are paid on an annual basis. That's why it's called annuities, right? And they are independent of grant. So in principle, so you pay annuities for an application, and you pay them after the second year in advance for the third year and every subsequent year after that. So during this whole prosecution period, you will be paying annuities to the EPO. And then after grant, you continue to pay annuities, but you pay them to the national systems, so the German, French, whatever validations you've done, or the UPC. So then you have a bundled annuity payment to the UPC. Now, your question is delaying annuity payments before grant. So delaying before a grant doesn't make any difference, right? So European patent, you pay them whether you have grant or not. And the question of delaying annuities, there's not much you can do because they are due. So after the second year, you have to pay for the third year. And there's no way to avoid that payment. What you can do is you can go for the 6-month surcharge period, which brings us back to the Paris Convention. Remember, I said the Paris Convention has this DNA in it, this patent DNA. So you will find that every jurisdiction in the world has a 6-month surcharge period for annuities. Why is that? Because that's enshrined in the Paris Convention. So we have inherited that rule, and the European system also has that. So if you want to delay payment, you can pay 6 months later, but then with a 50% surcharge. So that will be quite costly, but it's possible to delay 6 months. That's always guaranteed. But other than that, a due fee must be paid, right? So there's not much more than that you can do. I mean, you could also let the patent lapse and then try to reestablish it, but that will be extremely difficult, and that's not a typical method you want to employ to, as a restitutio. It's not a typical method to delay fees, right? That's definitely not an option. So other than the 6 months surcharge, there will not be any option to delay paying annuities for a European patent, regardless of whether before or after grant. Okay, let's move on a little bit. Nice questions, different spin, but we want to get to this question about the UPC. So remember, we were here at opposition, and I've only got one slide on opposition. We do a lot of oppositions and appeals, and they're very interesting, but they're very complicated as well, and there's a lot of procedure going on. But because this is a very important aspect of our prosecution system, I'm just going to show you briefly what happens in European opposition. Okay, so after examination and grant, publication of the grant, you get this 9-month period within which you can file an opposition with the grounds, and then the patentee has to respond within 4 months. Then you'll get the summons to oral proceedings and a preliminary opinion, usually about 6 months. And you can then file a replica, sort of a reply, or the patentee's rejoinder. So both sides get two times where they can file submissions. If you're quick, you can try to squeeze in more, but there is a kind of final cutoff deadline after which no more submissions will be accepted. And then after that, 2 months before the oral proceedings, and then you get the decision. You get the decision orally after the hearing, but then in detail in writing, where the decision has to be notified, of course, which triggers the period for appeal. And typically, the European system gives you a kind of intermediate decision. I won't go into that. It's usually an interlocutory decision. It's complicated. The reasons are complicated, but this has something to do with the fact that we still have an appeal procedure. So it's not usually not a final decision because you want to wait for the appeal stage. Okay, so that's basically in a nutshell the fighting opposition procedure, inter partes between two parties, the patentee and the opponent or multiple opponents against the granted patent. Okay, to wrap it up, there's one more peculiarity about the European procedure, which I want to mention, and that is what happens after grant. So after grant, we have this so-called validation stage where we don't actually get a patent, a valid patent just by granting. We still have to validate, that's what it's called, in the countries that we want to have coverage in. And there are now 3 categories of countries. There are the non-EU countries like Turkey, UK. There are the EU countries that do the traditional validation procedure. And there are the EU countries that also have the UPC. That was the question here about the UPC. So 17 EU countries have ratified the UPC agreement, and they now have a 1-month period in which you can validate a unitary patent for all of those countries together. So here you get a kind of block similar to what you would get in the US, of course, for all of the states. You would get 1 patent. Here you get, for 17 countries, a unitary patent. The other EU countries that do not participate and the non-EU countries have to go through this the classical 3-month, you have 3 months to validate in these countries. So here you have standard validation, where you pick and choose each of these countries. Sometimes you have to submit translations, sometimes you have to pay fees, sometimes not. And you would get then an effective right in each of these countries, but that's a partial right. So it's the European patent splits up into its national components, and each of these is then handled individually. So you have to pay annuities individually, nullity proceedings are done individually, infringement is done individually, except for the unitary patent block, which all of this is done in one block. Okay, so that's the basic system, the validation system. And now coming back to the question here from Mr. Locke, how does the unitary patent system help to cut down costs and streamline patent application process in Europe? Well, the patent prosecution, as you can see, is not streamlined at all. It's exactly the same as it was before, but there was only 1 prosecution, so nothing lost, nothing gained. But the advantage comes in post-grant proceedings because now we only have 1 annuity fee, and we have a lot of countries covered by this 1 unitary patent. So whereas you might have thought of not validating in Italy and Netherlands, now you kind of get them for free. So if you want to have a lot of coverage, definitely unitary patent is the way to go. And if you only want to have very few countries, yeah, you can still do it the traditional way. So let's just say, practically speaking, what most of our clients and most clients in general do is they validate in UK, Germany, France, because these countries do not require translation because of the London Agreement, and they give you the best coverage for your money, basically, the best bang for your buck. They give you the most effective coverage with the least work. But as soon as you want to go for more countries, then it starts to get expensive because, like Turkey, Norway, Switzerland, some countries will require a representative, they might require translations, they have extra fees, and then it becomes more cost effective to go for the unitary patent. So maybe you go for Germany, France, you cover with the unitary patent, maybe you include the UK as a separate validation, then you've got fairly good coverage in total. This will streamline your validation proceedings, and it will cut the costs for annuities and prosecution in the end, but only if you really need this coverage. If you only want to have 2-3 countries, then probably the standard validation is still cheaper and doesn't, if you take UK, France, and Germany, yeah, there's not that much work involved in validating these countries. And so the streamlining effect won't be very high compared to the unitary patent system. Okay, so then I hope that answers your question on the unitary patent system. Of course, we can make a whole session on this with 200 slides, all the details on infringement proceedings and validity and what have you on the unitary patent system. But today I wanted to show an overview and explain what the basic advantages are of that system. Okay, before we move on, there's one more question here. Are there any official fees reductions available for any category of applicants, such as small companies from non-EU countries? Okay, the basic answer, well, it's not quite so simple. In general, no, there are not. There are no SME reductions for external countries. But there is one rule for EPC member states. Okay, member states where SMEs with certain language conditions can get reductions. So there is one exception, but it requires a lot of conditions. So it has to be an SME, and it has to be a contracting state of the EPC with a special language requirement. So we're looking at Greece, Spain, Italy. These countries do not have one of the 3 working languages, and therefore they're at a sort of disadvantage, especially if they're SMEs. These countries get a special reduction of the fees. SMEs of these countries. But if you're coming from Japan, you're coming from Indonesia, India, US, no reduction there. So there's no particular rule there. Whether you're an SME or not, you still pay the standard fees. Right, so that's fairly straightforward to answer. Some people think that there is a reduction, but they forget that this is only for contracting states, because they look at the rules and they say, oh, okay, it says something about SMEs, but that's actually not applicable for Indian companies or Canadian companies or whatever. Okay, good questions here. And we can move on. So next topic is going to be PCT. Why PCT? Because a lot of the applications entering Europe are actually coming from the PCT system, and they are then called so-called Euro PCT applications. Okay, PCT, of course, worldwide coverage, 1970 at the WIPO in Geneva. Filing system, not a granting system, of course, and the final decision on grant is made in the national phase. We have 157 states to date. I checked this on the WIPO webpage. a couple more than 1 or 2 years ago, I noticed, interestingly enough, but still not as many, of course, as the Paris Convention, which is so ancient that everybody is a member. You still have some countries here like Pakistan and South America, interesting, like Argentina, Uruguay, Paraguay. There's still some countries here that are actually not participating in the PCT. Okay, the purpose of the PCT is to reduce filing costs, and you basically have one single filing which then nationalizes into all the designated states that you have chosen. And PCT timeline, I'm pretty sure that you're all familiar with this. You have the priority application, PCT filing after 12 months typically, then international phase with the search report and the ISR, international search report, and then the publication. A lot of the times we actually find that even US applicants use the EPO for their international search report, and that's just as well. One of the reasons why they do that is probably because when you enter the EP phase, you get then a full refund. And so if they're going to pay the fees anyway for the expensive examination fees at the European Patent Office, then they might as well pay it once and then get a refund. So probably that's one of the reasons. It could also be that you're dealing with a European client who has his headquarters in some European country, I don't know, Ireland, for example, and then you are forced, of course, to use the EPO as the International Searching Authority. But anyway, you get the ISR, and then after 30, 31 months, enter the national phases. European system has 31 months. And then after that, you end up with a supplementary search report at the EPO, and you validate, you grant and then validate in the national countries. So it's pretty much the same system after entry, except that you get this supplementary search report. Those of you who have been dealing with Euro PCTs, you probably know the procedure a little bit, Rule 161 and supplementary search report. I will show one slide on this just to kind of have shown it all, but it can get a little bit complicated. Okay, so basically summarizing what we've had before, we saw that we can get national applications in Europe, of course. We can get regional applications in Europe, and we can get Euro PCT applications, which then end up basically in the same examination proceedings as the others. Okay, so what are the advantages of PCT? Of course, single filing date, reduced costs, one single search and examination report, less formalities, translations, no local agents. Languages are important. So probably, as you know, also for the PCT, you can correct a PCT translation at any time during prosecution, sometimes even after. And that means that, say you have Japanese original priority application, then you file PCT at the JPO, Japanese language, enter the European phase with an English translation, and you find that there's a mistake in the English translation, you can correct that at any time. And so that's a big advantage here of the PCT system compared to filing directly with a translated English language application. And you can postpone the decision on which countries to pick up on, can postpone the costs, the intense costs of national phases, you can postpone that till the 30-month period. Disadvantages, well, this whole thing can kind of delay prosecution a bit because PCT application anyway are delayed by 30 months, and then sometimes they're prosecuted a little bit on the slow pace, I find, in national phases, especially in Europe. So it's slightly slower than if you filed a direct EP application. Okay, so one more question here. So there's a question here about, was talking about the high costs of the unitary patent process before the EPO. I've had the same reaction from SMEs in the US. Can you talk about situations in which it might be more advantageous to file in individual country offices rather than the EPO? Okay. Situations in which you would want to file in individual countries. Well, the most obvious answer to that is if you have a limited budget and you want to get a reasonable coverage in certain countries with a limited budget, then filing nationally can be the way to go. For example, some applicants only file in Germany. For example, automotive companies might only file in Germany because that's the main automotive producer in Europe and the main market. That might be enough for them. Filing only in Germany can be cheaper than filing at the EPO because the EPO official fees are much higher, like 5 times higher or even more. But at the same time, you have to deal with translation issues. So you might not be able to follow the prosecution that we are doing in German. And we have to translate everything. We have to translate the application anyway. So the cost advantage is somewhat mitigated by the translation burden. But in principle, that's a cheaper way to go than the European system, the EPO system. Some applicants go for UK and Germany. That's also seen quite often. That's still probably a bit cheaper than the EPO, a bit, but there it's close to break even. Because then you have 2 parallel proceedings compared to 1 EPO proceeding and all the office actions in between. That still might be cheaper because the official fees are so much less. So we see that occasionally. But by and large, your decision depends a lot on which technological field you come from. So if you're dealing with chemistry, biotech, anything, cosmetics, pharma, it's almost unheard of not to go to the EPO. So there's hardly any national filing in the chemical field. It's all EPO. It all goes to opposition, where money doesn't matter so much, but coverage does, and streamlined prosecution in English language, then you end up with the EPO. But in mechanics, automotive field, then sometimes you see applicants going the national route. Or if you have small inventors, like private inventors, they might only go for UK and Germany. You can still get that occasionally. But the bigger companies also, when it comes to software, I think bigger companies tend more to the EPO, except for very special cases where automotive, mechanical applications, sometimes they only go for Germany. So that's the pros and cons of filing nationally and filing at the EPO. It depends a lot on your technological field. It depends on your coverage, and it depends on your budget, basically, and which languages you want to be dealing with. But by and large, you can say bigger companies tend more to the EPO. They don't worry so much about the expense there. Small private inventors may go nationally to save costs. Okay, so that was a question then on what to do. After we have the PCT phase, we enter the European phase with Form 1200. You don't need to worry about this. This is what we will do. It's all in 3 languages, and you request examination. And okay, so here's a kind of a summary of what happens after you enter the European phase. Please brace yourself. This is a little bit complicated. I'm going to show it just so that you have it. Doesn't mean you have to understand everything. Maybe some of you are experts and you've already been through this, but I'm just going to show you the procedure when you enter the European phase. What rules apply? What are you going to come up with? Okay, so first question is, was the EPO the ISA? Because this is important, because if the EPO already was the ISA, they're not going to give you another supplementary search report, right? They're not going to duplicate their work. But let's assume that we have the ISA was JPO or USPTO or the Chinese Patent Office, then you will, If it's a no, then you get the Rule 161 communication, and you can make a kind of preliminary amendment to your claims if you want, or you just say, no, I waive this rule. And then if you do not waive any communications, then you will just get the supplementary search report and a deadline. Standard procedure. This is your first office action to which you have to reply. Quite straightforward, really. If you waived certain communications, then you might end up in examination straight away, or you might waive the Rule 161. You can speed this up a little bit, but in principle, this is the route you're going when you're coming from Japan, US, India, China. This is, you have a non-EPO international search report, you get the Rule 161, and you get the supplementary search report, which is in effect your first office action. And you start off from here. Okay, what happens if the EPO was the ISO? So for me, for my main clients, most of the time, the EPO was the ISO. That's a different situation because now we don't get a supplementary search report. We have to reply immediately to the Rule 161 within 6 months from the communication, unless it was positive, in which case we don't need to reply because there's nothing to amend. It's all perfect. And then we go straight for Rule 71.3 for grant. Okay, so this is the overview of what happens when you enter the PCT European phase for Euro PCT application. And after this, it's the same as usual. After this, it's just standard examination office actions up to grant. It's only this bit that's a little bit complicated and depends on the case. But in effect, you don't need to worry about this. We will deal with whether it's a compulsory, a mandatory response is required or not. We'll deal with the due dates. You'll just get communications from us explaining when we need a reply, and you don't need to worry about all the rules behind it, the mechanics behind it. Okay, so as a brief summary of what we have said, today we talked about national direct filing, Paris Convention, regional filing, PCT, and okay, well, TRIPS is a kind of add-on which might influence these other rules, these other legal systems. And today we saw a lot about regional filing at the EPO. And now I have a brief question to you because we have come up to the 1 hour mark. And I could talk about utility models. That's a sort of add-on chapter for about 5 to 10 minutes. Or we could just call it a day. So what do you think? Do you want to have a question session where you can post your questions on what we have dealt with? Or do you want to hear a little bit about utility models, which is another way of filing in Europe? What do you say? You could just post your comments in the chat. Or if Scott says it's enough, 1 hour is enough. Okay, I'll just see who's up for it. Okay, so we have two votes already, 2 or 3 votes for utility models. Then I'll wrap up with that. Then we'll.
That sounds good.
If Scott allows that, then okay, good.
Absolutely. Thank you.
Okay, no problem. Okay, utility models. So this is has different names in different countries. In Germany, it's called Gebrauchsmuster. Other countries, different names. And they look the same, but there's subtle differences here. You can see this U1 here in this German publication indicates that this is not a patent. This is a utility model. And the U is also used in other countries. What are utility models? Well, they're sort of protection rights for minor inventions. Their purpose is to innovate or to provide incentives for small improvements. And they are typically have a lower standard for obviousness. Maybe even no standard for obviousness. It's only novelty that is a requirement. And they are also included in the PCT, in the Paris Convention. The Paris Convention already foresaw no utility models, but there's no international treaty governing them. So this is typically only national law. And quite a few countries have utility models. you will probably notice that the countries that don't are sort of belonging to the Anglosphere or were at some stage in the British legal system, like India and UK, Canada, US. Not Australia, but most of the other countries, or a lot of the other countries, actually have utility models in some form or another. In particular, like Japan, China, these are heavy users of utility models. And we also have them in Germany, where they're also very important, actually. Germany, Austria, but also France. But in Europe, it's mainly Germany that uses utility models. Grace period. So as you probably know, the European system does not really have a grace period, at least not anywhere near what we are used to from the US. But there is an exception, and that is the utility model, which provides a 6-month grace period. Why is this? Well, comes from historical reasons, because when the European system was set up, the EPO system, 1970 something, when they set that up, they streamlined all the national patent proceedings. So they all kind of were straitjacketed into the compromise solution. And in this sense, the UK system prevailed and there's no European EPO utility model. But the German system still kept its old appendix, and they didn't change the rules either. So they had this grace period historically, and that stayed that way as well. So this can be a useful tool if you mess up something with a priority, or there's a disclosure by your inventor accidentally, and that forestalls your European patent. It's no longer novel. There's no way to save it. You can still sometimes save the day by filing a German utility model. That gives you at least some coverage in Germany for at least 10 years, better than nothing. So keep that in mind. That might save your application or your invention at some stage. How do you get a utility model? Well, you go through the national authorities. Can you get them in parallel? In Germany, you can. Usually not for the same invention, but in Germany you can. That's very useful. And lots of other countries don't allow that, like in China, for example. Eventually you have to decide one or the other. Last couple of weeks ago, we saw from the GIP China colleagues, they said, well, utility model, when you enter the PCT phase in China, you have to decide, are you going to go for a utility model or a patent? Sometimes you can convert them from one to the other. I'd say most useful is utility model in Germany, which you can get parallel to your European patent, because when it comes to infringement, you can immediately enforce a utility model. So when you want to sue somebody for infringement, of course, normally you have to wait until grant. You can't really sue anybody, especially you can't get an injunction or anything like that. The real powerful infringement tools you can't get until grant. Okay, but if you're mired down in some kind of prosecution at the EPO and you want to stop somebody quickly, you need to stop them fast, then you go for the utility model, which is registered in 3 months without any examination. And you can immediately enforce that and sue against that infringer. So that's why utility models in Germany, for example, are very useful, especially when you come to infringement, or as a kind of flanking right to back up your patent rights if you have some very important invention. Okay, so there are differences to patents. As I mentioned, registration is very quick, but of course there's no security in the sense that there's no prosecution behind it, right? So you don't really know whether this is a valid utility model or not. You have to rely on your what you know, and it will then be decided in court whether this utility model stands or whether it will be invalidated. Examination fee, there is no examination fee, and the maintenance is a lot cheaper, of course, but you only get 10 years instead of 20. And it cannot be obtained in certain fields of technology, and also not for processes, in Germany at least. So you can get a utility model on products or machines, devices, but you can't get it for methods or uses or anything like that. That's also can be difficult when you're looking at pharmaceuticals or software. Yeah, but by and large, most things are accessible to utility model protection. Okay, so then final slide. When do you want to get a patent? When do you want to get a utility model? Well, if you need quick protection, immediate enforcement, so that you can go to the civil courts and sue somebody, then you go for the utility model, probably also the patent if you're really into infringement. And some products may only require 10 years protection. Some simple products that come on the market and then there's a phase and then they come off the market very quickly, then that might be enough anyway. Very low costs. But of course, yeah, not accessible to all kinds of patent claims, and typically only for small improvements of existing products or just to flank your very important patents need sometimes to have flanking protection just in case they're invalidated somehow or can't be enforced or whatever. Then double protection can be useful. Okay, so that's kind of a summary on utility models, and that will be basically it. So what did we see today? We discussed direct filing and the Paris Convention. We discussed priority, EP prosecution, PCT, and then entering the EP phase, of course. And finally, we saw another way to get inventions protected in Europe via utility models and why they are useful when you can apply them. So these are the main ways to get protection in Europe. I hope that I've given you a quick summary of what you can do. Of course, we didn't go into any details, really. We didn't talk about any particular topic in any depth, but this was not the intention. The intention today is just to give you an overview so that you can come back when you get more questions. What was this, or can you give more details on that? You can at any time write me an email or ask questions later on.